This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why it's best to buy your own UIM cover rather than to rely on statutes, and why an attempt to create underinsured motorist coverage from a statute failed. In Scott C. Malzberg versus Caren L, Josey, and James River Insurance Company, a September 27, 2022 decision of the Superior Court of New Jersey Appellate Division, Scott Malzberg appealed from the Law Division's order granting summary judgment in favor of James River Insurance Company, dismissing plaintiff's claim for underinsured motorist coverage. The case presented a question of first impression regarding the New Jersey Transportation Network Company Safety and Regulatory Act. Plaintiff was injured in a motor vehicle accident while he was operating his motorcycle as an Uber Eats delivery driver. The sole legal issue raised by the appeal was whether the act, which requires transportation network companies to provide at least $1.5 million in underinsured motorist coverage, applies to food delivery services such as Uber Eats. In granting summary judgment dismissal, the trial court held that the act only regulates companies that use a digital network such as a mobile phone application to connect a rider to a prearranged ride, and that the act applies only to the prearranged transport of persons and not to the delivery of food. The court found that nothing in the statutory text or legislative history of the act suggested that the legislature intended to regulate app-based food delivery services. Plaintiff had enrolled with defendant Portier, LLC, a subsidiary of Uber, to use his personal vehicle, a motorcycle, to deliver food. The Uber Eats app allows food delivery service providers and restaurants to connect with each other so that they can fulfill orders placed by consumers. On August 17, 2017, plaintiff was in the process of making a food delivery for Uber Eats when a vehicle driven by defendant Caren L. Josey collided with plaintiff's motorcycle. Plaintiff was thrown from the motorcycle and sustained significant injuries requiring multiple surgeries. Josey was insured by Cure Auto Insurance with bodily injury liability coverage limited to $15,000 per person. Plaintiff's injuries exceeded the limits of Josey's personal auto insurance policy. Portier had procured a business auto insurance policy from James River to protect it from liability as a result of the actions of Malzberg. However, the James River policy defines an insured to include the delivery drivers who have entered into a contract to use the UberPartner application and who have logged into the UberPartner application. But it did not provide underinsured motorist benefits. A stipulation of dismissal with prejudice was filed as to the defendant Ryder Insurance Company on June 29, 2020. The New Jersey Supreme Court had clearly stated that the overriding goal of all statutory interpretation is to determine as best we can the intent of the legislature and to give effect to that intent. Consequently, to determine the legislature's intent, the court looks to the statute's language and gives those terms their plain and ordinary meaning because the best indicator of that intent is the plain language chosen by the legislature. The core issue, therefore, was whether the Act regulates app-based food delivery services or instead is limited to regulating companies and drivers that arrange and provide transportation services for passengers. Now, the statute defined transport network company to mean a corporation, partnership, sole partnership, or other entity that is registered as a business in the state or operates in the state and uses digital network to connect a transport network company rider to a transportation network company driver to provide a prearranged ride. Transportation network company driver or driver meant a person who receives connections to potential riders and related services from a transportation network company in exchange for payment of a fee to the transportation network company and uses a personal vehicle to offer or provide prearranged ride upon connection through a digital network controlled by a transportation network company in return for compensation or payment of a fee. Close quote. Most notably, nothing in the Act refers to the delivery of food. The absence of any reference to food delivery in the definition section stands in stark contrast to the interrelated definitions that refer explicitly and repeatedly to rides and riders, which clearly denote the transport of human passengers. The absence of any reference in the definition section to any vehicle that transports goods rather than passengers supported the court's conclusion that the legislature in enacting the Act was concerned only with vehicles while they are being used to transport persons. Aside from the definition section, the text of the entire Act includes only one explicit reference to services that involve transport of something other than persons, and that reference is done in the context of explaining what the transport network companies and drivers may not do if they are to remain within the scope of the Act. In sum, the court concluded that the primary question posed in this case is easily resolved under a plain text analysis. The statutory scheme comprehensively regulated app-based services that provide rides to human passengers. As the court stressed, nothing in the statutory text mentions, much less comprehensively regulates, the delivery of food. In these circumstances, the court need not consider extrinsic sources to determine legislative intent. The appellate court found further extrinsic support for its interpretation of the Act in the regulations that have been promulgated by the Act. In the final analysis, the court concluded that it is for the legislature, not a trial or intermediate appellate court, to fill the void to which plaintiff alludes, where the statute fails to deal with those who deliver food like the plaintiff rather than those who deliver people. The Court of Appeal refused to venture an opinion on whether that pending legislation supports or undermines plaintiffs' arguments on this appeal because reliance on proposed or pending legislation to interpret existing statutes is of little value. There is no value from legislative proposals that are not enacted into law. The Act in its present form does not apply to the circumstances of Mr. Malzberg's case. In my opinion, the suit was imaginative and provided interpretations of a statute that are limited to people who deliver people, not food or other products. Malzberg, through his employer, had liability insurance coverage, and if he wanted to be protected, could have purchased UIM coverage for himself. Neither he nor His agency employer did so. He was appropriately unable to get the court to expand the meaning of a statute by suggestion. Insurance is not a right, it is a choice. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone interested by simply clicking on the link zalma.com/blog. Please subscribe so you never miss a blog posting or a video. If you found this video useful to you or your colleagues, please let them know so that they too can subscribe to the blog and to the video. And also consider my locals.com community and my Substack publications. Thank you for your attention.